Part 1, Evidence of Mass Illegal Cremations, from a report discussing the Committee for Coordination on Disappearance in Punjab (CCDP) and the work of Jaswant Singh Khalra. CCTP Committee for Coordination on Disappearance in Punjab was formed on 9 November 1997. Its purpose was to investigate and bring attention to people who had disappeared in Punjab, particularly during the militancy period 1980s to 1990s. The main aim of CCTP were collect information, to voluntarily collect information about missing people and make sure that cases of police abduction and illegal cremations were properly investigated and ended with justice. Ensure accountability, to create a system where the state and police could held accountable and to build public pressure so that they could not escape responsibility. Change in law, to urge the Indian government to follow UN laws about torture, disappearance, and compensation for victims of power abuse. Start public discussion, to begin a national discussion about state power, accountability, justice, and to work with other groups across India on these issues. Background: Jaswant Singh Khalra's work. Jaswant Singh Khalra was the General Secretary of the Akali Dal's Human Rights Wing. In 1995, he began to expose how Punjab police abducted people and secretly cremated their bodies, calling them unidentified. On 6 September 1995, Khalra himself disappeared after being abducted by Punjab police commandos. What Khalra found. In January 1995, Khalra got official records showing that Punjab Security Agency had secretly cremated thousands of bodies. He found entries in the firewood purchase registers of 3 cremation grounds in Amritsar. These showed how much food was brought, enough for hundreds of bodies. Khalra said most of these were illegal cremations of people arrested without record, accused of being linked to separatist court case. Khalra took these documents to the Punjab and Haryana High Court, asking for an independent investigation. However, the court dismissed his petition, saying he had no legal standing or personal involvement in the case. This decision was shocking because it ignored the seriousness of the allegations. In 1981, Justice P. N. Bhagwati of the Supreme Court defined public interest litigation (PIL) as a way to bring justice within the reach of the people, vulnerable masses, and helpless victims of injustice. Earlier, only a person directly affected by an issue could go to court. This was called a ius standi. But the Supreme Court changed this law, saying that any citizen with enough knowledge and genuine interest could file a case for the public good, even if they were not personally affected. Meaning of PIL. A PIL is a case filed in court for the benefit of the public, especially to protect fundamental rights of people who cannot approach the court themselves. Articles involved. Article 32 gives the right to move the Supreme Court for enforcement of fundamental rights. Article 2 to 6 gives similar power to the High Courts. Examples of cases: S.P. Gupta, West Union of India, 1981. This case allowed its citizens to bring cases in public interest. Sheila Varse, West State of Maharashtra, 1983. A journalist filed a case about poor conditions of mental asylum inmates. The court said she could not continue because she was not directly affected, but it still ensured the rights of the victims were protected. The courts began accepting letters, telegrams, and newspaper reports as valid sources for starting a case if they revealed violence of human rights. This marked a new phase in Indian justice, where courts became more accessible to common people.